Hello, my name is Melissa Worth and I am a solicitor helping individuals and businesses to resolve their commercial disputes. I am continuing with my weekly law review, and this week I am looking at a case which is of relevance to insolvency practitioners. It is the case of Uralkali and Rowley and another, and the citation is EWHC 3442, and it's a 2020 case. Mr. Rowley and Mr. Baker were the administrators of Force India Formula One Team Limited. The claimant, Uralkali, was one of several parties interested in investing in Force India. Force India went into administration on the 27th of July 2018. The administrators had proposed two ways forward for rescuing the business. The first was to secure investment via a share sale. The second was to sell the business and assets. As Force India was competing in Formula One, if the business and assets were to be sold to another entity, the approval of various Formula One companies would be required because of the commercial rights. In addition, the other Formula One teams would need to be consulted if the new entity were to be eligible for the prize money. There was also some time pressure for getting the deal sorted, as the Belgian Grand Prix was due to take place on the 31st of August 2018, and things were further complicated because a significant beneficial owner of the issued share capital of Force India was the subject of a freezing order. The successful bidder was Racing Point, and the business and assets were sold to Racing Point on 16th of August 2018. The claimant, Uralkali, was therefore an unsuccessful bidder and was unhappy with that outcome. Uralkali brought a claim against the administrators, alleging that the administrators had made negligent misstatements during the bidding process, and that they had carried out the bidding process negligently, and that they had also breached their duties of confidence. The claimant alleged that the administrators had represented that the bidding process would be a level playing field, and that the successful bidder would be chosen on the basis of the best offer for the business and assets. The claimants asserted that its bid of the business and assets was more favourable than Racing Point's offer, and that, therefore, the administrators were negligent. Further, Uralkali argued that one of the administrators had provided information to Racing Point in breach of confidence. The court held that office holders could be liable for negligent misrepresentation. The court referred to the 2018 case of Steel v NRAM Limited, which had recently gone over the relevant principles. However, the court also highlighted that administrators' conduct is governed by Schedule B1 of the Insolvency Act 1986, and that the administrators' objectives are to rescue the company as a going concern, or to get a better outcome for the creditors as a whole than would be the case if the company were to be wound up. The judge said that, "I consider that the court should be very slow to impose on an administrator a duty of care, which might fetter his discretion to make decisions in accordance with Schedule B1. Courts are reluctant to impose a duty of care which cut across the duties of or interest of the administrators." The administrators did not perform a service for Uralkali, and Uralkali was not owed a duty of care pursuant to Schedule B1. Therefore, the administrators were not liable to Uralkali for misrepresentation or negligence. The judge also held that the information that Uralkali had complained had been released to Racing Point did not breach any duties of confidence. All that was said was that the other parties were exploring a rescue by an acquisition of shares. The judge said, amongst other things, that such information did not have the necessary quality of confidence, and nor did it fall within the equitable duty of confidence. Finally, the judge found that a joint office holder is unlikely to be held liable for a colleague's acts, especially if they are not on notice of the wrongdoing. The claim was dismissed. This case demonstrates that it is highly unlikely that insolvency practitioners will assume duties to prospective bidders when dealing with insolvent businesses. The court will also be reluctant to interfere with or cut across a decision made by a practitioner using his or her discretion pursuant to Schedule B1 of the Insolvency Act. If you have any queries or comments about this case, please do get in touch. Many thanks for watching.